Hi, this is Andrew Winters. I'm one of the partners at Cohen and Winters, and one of the most common questions we get is about getting something wiped off of your record. For whatever reason, New Hampshire calls this an annulment, although almost every other state calls it expungement. And we have a lot of material on our website about what types of convictions can get wiped off of a record and when. Certain convictions, unfortunately, cannot get wiped off of a record. For every other type of conviction that can be wiped off, there's a waiting period, and it has to go through a judge. So a judge has the final decision about whether something can get wiped off of a record. What I want to talk to you today about is not the ins and outs of which types of convictions can get wiped off. We're going to do more videos on that, but what I just want to talk to you today about is the procedure for doing it, assuming it's the type of thing you can get cleaned up. So here's how it works. First, you file a petition. Now, when we're hired, we obviously prepare the petition. It has to be signed by the client, and the petition states that it's, what the conviction is for, and that you haven't had any trouble since, as well as a bunch of other things about the case. So that gets filed with the court. Then what happens is the court processes it, and it gets sent to the Department of Corrections. The Department of Corrections then sends a form to the client's residence, and the client has to fill out that form and pay a fee to the Department of Corrections. This is where a lot of people get stuck because they assume that they hired us, we're going to deal with that, and we'd be happy to deal with that, but the Department of Corrections always sends that form to the client's house. So if the client brings us the form, we'll help them fill it out and sign it, but a lot of times it's a very simple thing. They can just sign it, and they have to mail a check back to the Department of Corrections. The Department of Corrections then issues a report to the judge, and most of the time in district court, unless the prosecutor has some problem or the Department of Corrections has some problem, as long as the person has not had any arrests or troubles with the law since their conviction and everything appears to be straightforward, the judge will approve the petition to annul. And that's not the final step, however. After the petition is annulled, then the client gets another piece of mail from the Department of Safety. And here they have to send a check to the Department of Safety, and this is for the luxury of having the Department of Safety wipe it off of your record in their system. So it's kind of like the old saying about a tree falls in the forest. If the judge grants the annulment, that's great, but it doesn't actually help you unless the Department of Safety enters that annulment into the record, which is what wipes it off of the record. So you'll get a final piece of mail even after the annulment is approved telling you to mail in a check to the Department of Safety. And you can't rush that. You just have to wait for them to sending you mail. It's usually a few weeks after. And there's fees along each way. So it's $100 right now, as of the time I'm doing this video in 2021, it's a $125 fee to file the petition to annul. Then it's a $100 fee to the Department of Corrections to run your record and write a report to the court. Then it's another $100 fee to the Department of Safety. Some of these can get waived if the person was never actually convicted. They just want to annul their arrest. But if it's a conviction, then all those fees have to get paid. All those steps have to be taken before it's officially off of your record. Again, this is Andrew Winters, and we just want to walk you through this procedure since we get these questions all the time. Feel free to contact us with any more questions at Cohen and Winters. Thanks, and have a great day.